Morning everybody, thank you for joining us. I hope you can hear me. My name's David Owens. Welcome to our webinar. This is on construction and COVID. Can your construction contract continue? I have no idea why we've got a webinar with all the words begin with the word letter C. It seems like some sort of practical joke that hasn't been explained to me, but still. You'll probably by now have heard the old Chinese curse, may you live in interesting times. It's a curse, of course, because boring times are peaceful and tranquil. And interesting times are the exact opposite. Well, we certainly live in interesting times now, so much so that I hanker back to the times when Brexit was all the bosses to worry about. But times change, the peak has hopefully passed, and there's a prospect now of a cautious return to work. Construction projects that had slowed, and in many cases stopped, have slowly restarted. We're going to talk today about how to deal with delay caused by COVID under standard form construction contracts, about managing construction contracts going forward, and about what the latest guidance says, and about how to deal with new projects and with construction contracts that haven't yet been signed. Right, now hopefully if the technology all works, we're going to all introduce ourselves. My name is David Owens and I'm a partner in the construction team here at Sharp Pritchard, and I deal with contentious construction matters, construction disputes and resolving disputes. And I'm joined by my colleagues Rachel and Michael. So hopefully we can now go across and see both of them.
So you should now be able to see me. I think the red line is now around my image. So someone informed me that that means that I'm now live. So my name is Rachel Morris-Smith, I'm obviously not Michael, and I'm a Senior Associate in the Construction and Commercial Contracts team at Sharp Pritchard. I predominantly deal with non-contentious matters. I think there's a lot of the clients that I normally work with who've dialed in, or however it is that you access the webinar, who will recognise me, but I also do some element of contentious construction work as well.
Hi Michael, are you there?
Yeah, I'm live. I can see the red screen around me. But I'm a trainee solicitor here at Sharp Pritchard. I assist in both non-contentious and contentious construction matters. And hopefully the technology will work better from now on.
Of course it will. Right. Back on me in my front room. Okay. Now, I'm sure you've seen enough of my dodgy light fitting already, so we're going to hopefully now go across to the slides. Are we able to put the slides up now, please? Brilliant. Great. Okay, and I am going to try and take control of the slides. Oh, this technology is so smooth. Right. So this is what we're talking about. This is who we are and our email addresses. And here we are. This is what we're going to talk about. So, as we said, I'm going to talk about the relevant contractual clauses in the standard form contracts. Then we're going to go across to Rachel, who's going to talk about whether your construction contract should continue and guidance on their management. And then finally across to Michael, who's going to talk about what to do if you haven't yet signed your construction contract or are still procuring it. Here we go. Okay, how is COVID-19 treated under standard form construction contracts? The question is, of course, what clauses should we be looking at in a contract? What's likely to be the most relevant thing under that relates to COVID? The most obvious clause to look at is your force majeure clause, if you have a force majeure clause in your contract. Force majeure is a weird thing because it's obviously a French phrase and it comes from civil law jurisdictions such as France. And digging about on the web, I found this. The term force majeure is derived from French law, a civil law system, but has no recognised meaning in English common law. The term should therefore only be used in agreements where it is properly defined. And this is, of course, a bit ironic because it's used by JCT and they don't bother defining it at all. Force majeure is generally taken to mean an exceptional event beyond the reasonable control of the party concerned. So there you're talking about the contractor if they're trying to claim a force majeure event has occurred. And it's an event which makes it either physically or legally impossible to meet the terms of the contract. So it doesn't necessarily have to be impossible to complete the building, but remember that the term of the contract is completing the works by the completion date. So it has to be impossible to complete by the completion date. There has to be an element of you're being prevented from completing the works that you're required to complete under the contract. And as it says, force majeure is not implied into English law contracts. It has to be an actually defined term. So if it's not defined, there's no force majeure provisions under your contract. So I guess the question obviously that arises is whether COVID amounts to a force majeure event. I think here the important thing is to think about is actually what the delays are that you're experiencing, what the delays are that the contractor has. If following the lockdown announcements, the site had to be closed for health and safety reasons, and that sounds like it's pretty much going to be a force majeure event. It meets all the requirements above. But if you have got a situation where a contractor was horribly in delay already when you're coming into late March, and they are slightly delayed by problems around COVID and workers not being able to get to site, then clearly all of the delay is not going to be down to COVID, and it's not going to be the delay is not going to be entirely caused by any force majeure event. The other thing to look at is what your clause actually says. We're going to turn to the two standard form contracts that we're talking about in a moment, NEC and JCT. But you may well not be operating with an NEC contract or a JCT contract. You need to actually look at what your clause says. We've certainly been advising on a number of PFI contracts recently, and one of the things that we found is that if you have a list of force majeure events in the contract, it may well be that COVID simply doesn't come under any of the entries that you have down for your force majeure point. Right, moving on. By the way, I can see there's questions coming in already, and I'm very grateful for that. Thanks very much. Our plan is that we are going to try and deal with all the questions at the end. So we'll try and sort of, in case we get more than one question on a similar point, and I apologise for this. If we were doing this in the office, it would obviously be a lot more interactive, but hopefully we'll get that element of interaction at the end where we try and respond to questions. Right, as I say, we're going to try and talk about the situation under JCT and under NEC. Under JCT, the question of whether a contractor can claim for an extension of time. Obviously, to claim for an extension of time, they have to show that there's a relevant event, and there is a relevant event for force majeure. It's the last one on the list. It's, as I say, under JCT, force majeure isn't actually defined. They just simply refer to force majeure. So I think in those circumstances, you would expect to go back to the sort of generally understood definition of force majeure that we had on the previous slide. As it says in the third bullet point down there, the constructor has to demonstrate that it's making its performance impossible. It's not enough to state that it's just a bit more difficult or a bit more expensive. So if you're in a circumstance where the contractor is just saying, well, I'm having to provide hand sanitizers and face masks, and my costs have all gone up, this isn't going to hit the requirements of force majeure. They have to show that essentially they can't go on with the project, or the project is now completely different to what it was prior to the COVID event. There has to be this, as I say, this element of prevention.
Yeah, and I think I'd just chip in on that bit, David, to say, as I'm sure many of us have experienced in the past 8 weeks, the position in contracting in law more generally is almost a moving feast. So something that was applicable as at the day that lockdown first occurred may not be the advice or the position, a week later, or even, it was kind of day by day. Things were changing when this first started. So I think it's definitely the case that under that particular force majeure provision, an extension of time claim that may have been legitimate at the point of lockdown is becoming increasingly less legitimate as time has gone on, and we'll deal with that in more detail in the later slides. But it's just to note that obviously there's moments in time here where certain advice would apply, and at other times less so.
Yeah, absolutely, that's very true. And yes, we will come on to that in a second. get the slides to move on. In terms of in JCT, obviously there's this split between a contractor getting an extension of time and a contractor being entitled to loss and expense. Under JCT, while force majeure is a relevant event, it isn't a relevant matter, and therefore a contractor isn't entitled to loss and expense under the terms of the contract if they're claiming a force majeure event. But as we say on the slide, employers may want to consider some cost sharing with contractors in relation to COVID, especially where there's a potential for your contractor becoming insolvent, and that has to be the case with an awful lot of contractors at the moment. And I believe that that's a point that Rachel's going to talk about a little more.
Yes, yeah, I will deal with that in a bit more detail in terms of the relief and cost sharing going forward.
Fantastic. Okay, we're going to now turn to NEC. I just a brief word about the illustrations on these. Michael was responsible for all of the pictures on these slides. I did say to him when we were doing the run through, why is there a picture of a bridge on the NEC slide? And he tells me that this is the Menai Bridge. Menai Bridge was designed by Thomas Telford, and the NEC contract is published by Thomas Telford, the publishers. So there's a, it's a clear and logical link here, obviously. NEC, unlike JCT, you don't get the halfway house in NEC of allowing time but not money. And then under NEC, you either get both time and money or neither. To get both time and money, a contractor would have to show there's a compensation event. While the phrase force majeure isn't actually used in NEC contracts, there is something in there that looks very much like a force majeure event. It's the last of the compensation events. It says an event that stops a contractor from completing the work so long as neither party could have prevented it. An experienced contractor wouldn't have judged at the contract date that it had such a small chance of occurring that it would have been unreasonable for the contractor to have allowed for it, and it isn't another compensation event. So you sort of read that and think, well, yes, that probably fits in with COVID. If you have severe delays on site, it seems to fit all of those as a result of the health and safety problems around COVID. It seems to fit all of those requirements. I would say there's a couple of things to note here. It first of all obviously depends on what the contract date is. If you look at that second bullet point, it's an experienced contractor would have judged at the contract date that this had such a small chance of occurring. It would have been unreasonable for the contractor to have allowed for it. If your contract date was last year sometimes, then that's absolutely going to be true, isn't it? If your contract date is January or February this year, maybe. End of February, beginning of March, we start to get into a grey zone. Would they have judged it so unreasonable that they shouldn't have allowed for it? Probably not. The other thing to bear in mind is the infamous time bar under NEC. Under clause 63.1, that specifies that if the contractor does not notify a compensation event within 8 weeks of becoming aware of the event, he is not entitled to charge to a basically to time or money. So 8 weeks. The lockdown was declared by Boris on 23rd of March, and interestingly, 8 weeks after that is this Monday coming up. So there's a reasonable argument that if your contractor hasn't asked for a compensation event by Monday, it may well be in trouble with the time bar. That said, I wouldn't rush to tell them on Tuesday that they're too late to do so. There's certainly an argument that the COVID Act didn't come out until the 26th of March, I believe. So there's probably still a few more days there if they want to say they didn't know what the requirements were until the Act was actually published. Frustration. I'm not going to say an awful lot about this slide. It's mainly up there because we like the Lego, the picture of the Lego man and the golf ball. Frustration is one of those clauses that's the last resort of the desperate man. The courts really don't like agreeing to that contracts have been frustrated. And I should just explain, frustration is the circumstance where it's become impossible to continue carrying out the contract. So a contractor would have to argue that it was now impossible for them to complete the works because of the effects of COVID. In addition, courts don't like deciding that contracts have been frustrated in circumstances where there is a force majeure clause. So if you have a force majeure clause in there, you should certainly be looking at that first. You're unlikely to have a decision by the court to say that a contract's been frustrated. If they do say it's frustrated, then that has the effect of terminating the contract. But as I say, it's desperate times if you're starting to argue that frustration has happened. Other potential relevant events or compensation events to bear in mind: statutory powers. Under JCT, exercise of statutory powers, so potentially the publication of the statutory instrument by the government is a relevant event. And under NEC, if you've got option X2, there's a clause in there making any change in law. Similarly, it's going to be a compensation event. Suspension of the works. Under JCC, if there's an instruction to postpone, that's going to be a relevant event and also probably a relevant matter. If under NEC, if you've got an instruction to suspend is going to be a relevant matter. There's another one there. It's worth bearing in mind that clause 19.1, shuffles papers and tries to find clause 19.1, requires the project manager to, here we go. It requires, if an event occurs that stops the contractor completing the works by the date shown in the accepted programme, and which neither party could prevent, and experienced contractor with a judge at the contract date to have had such a small chance of occurring that it would have been unreasonable for him to have allowed for it, the project manager gives an instruction to the contractor stating how he is to deal with the event. So if you've got a particularly diligent contract manager, a project manager who has given an instruction back at the end of March to the contractor about exactly how they are to deal with the event, then the contractor can obviously if an instruction by the project manager delaying the works becomes a compensation event. So that's something to bear in mind. Okay, so we've talked about delay. What about the circumstance of perhaps if your works have only just started and you've decided you don't want to go ahead with them, or if you've started the works and the costs now, because of the effects of COVID, now look prohibitive, or if your contractor is on the verge of insolvency and you want to bring things to a halt at this stage, you need to look at your potential options in relation to terminating the contract. Again, we're going to do this for JCT and then for NEC. Under JCT, there's a right to terminate if the works have been suspended for force majeure for 2 months. Under those circumstances, you need to, once that period has come to an end, and for example, if the suspension happened around about the 23rd of March, then obviously we're getting close to the 2-month period now. But if that happens, if you get into a circumstance where the works are suspended for 2 months, then you need to give 7 days notice that works have been suspended for force majeure for 2 months to the contractor, and then after that 7-day period, if the suspension continues, the contract can then be terminated. It's always worth saying that termination is absolutely the nuclear option under any contract that carries great risks, and if you end up in court and the court finds that actually this wasn't a force majeure event for some reason, then it can be found to be a repudiatory breach of contract that has just occurred by you telling the contractor that the contract had terminated, and you're into huge losses under those circumstances, potentially large damages claims by the contractor. So if you're going down this sort of route, I think I would definitely advise to try and do so by consent with the contractor. Try and get agreement that this is actually going to be an agreed termination.
Yeah, I think it's also worth saying at that point, David, and this will apply equally to the NEC, obviously the government guidance that has been issued is all geared towards ensuring that projects continue and that termination doesn't occur. So, and I think that with many of the contracts where contractors had suspended, as we mentioned at the top of the session, most contractors are returning to sites. That's well within that specified period of 2 months under a JCT. So that termination right then falls away.
Yeah, absolutely, absolutely. It's obviously not something you want to do lightly. It's only the sort of route that you would go down under extremis. As I say, best if you are thinking about doing that to try and do so with agreement of all parties. The other thing that's worth saying, of course, as well around termination and JCT, and indeed on NEC, is if you do end up in a termination situation, remember that the final accounting process is completely different to the normal final accounting process. To make sure that your project manager follows the termination account provisions rather than the normal final account provisions. Just turning to NEC, NEC has what they call the termination table, presumably because they like alliteration too. And one of the options under the termination table are the circumstances where if an event stops the contractor completing the whole of the works, the contractor will not be able to meet the date of completion, and you have a prediction that the delay to the works is at least 13 weeks. Then it's open to the parties to terminate the works. Right, I think we are now going to pass over to Rachel if the technology works.
I've requested control, so hopefully I should now have the ability to move the slides. I just wanted to pick up on a couple of points, just in terms of when this first occurred. Obviously, important things when you're considering delay is, of course, to keep contemporaneous notes and records. It's just the same for the COVID-19 situation as it is any other delay event. So it's really important that you've been keeping your notes, which I know is difficult when there's lots going on, but also worth noting that, again, I think we have had clients who've said to us, oh, well, the contractor hasn't actually notified us, citing the relevant contractual provision, using the form of notification that we would have expected. And I think we've been advising our clients to take a kind of pragmatic commercial view on that. And the guidance which has been issued subsequently has supported that view, which is that you should be working with your contractors to ensure that those notices are issued, and you should be asking your employer's agent or consultants to then assess that relevant event in accordance with the requirements of the contract, and again in terms of the NEC in accordance with that compensation event regime.
Yeah,
so I think
we're always in these sorts of circumstances. You know there's potential issues and a potential dispute further down the line. It's vitally important to keep good records and make sure that the contract is followed scrupulously in case you're going to end up in a dispute following that. Yeah,
great. So on to my set of slides, which fittingly start with a very perplexed face emoji, which I'm sure is something we have reflective of how we've all felt over the past 8 weeks at some point or another. So should our construction contract continue? So I think essentially my first comment on that would be, even from the very outset of the lockdown, I think the government left the door slightly ajar for construction to continue, and I think that's reflective of the importance of the construction industry to the economy of this country. So I think they've been kind of edging us down the route of yes, it can continue, but what that looked like was very, very unclear at the outset. So let me see if I can now move the slides. There we go. So government guidance, as I'm sure you'll all be aware, there's been a number of public procurement policy notes, or PPNs as we like to call them. One of the most important ones has been PPN 0220, which focused on the contractual treatment of suppliers and contractors, and essentially the important takeaway from that was that employers should be exercising discretion in order to assist what would be categorised as at-risk contractors. So even though in terms of your contract you might not be obliged to offer a form of relief, that actually you should be considering whether that would be appropriate, essentially to avoid mass insolvency scenarios in the construction industry. So that was the kind of message that came out from PPN 0220. And then the star of the show that came following that for construction purposes was then the guidance that followed on from PPN 0220, which really set out in very simple and straightforward terms what those relief options should look like. And the government even went so far as providing some template drafting for both the JCT and NEC forms of contract. So the variation drafting provided in the guidance encompassed essentially 4 key options, which were increased frequency of payments. So instead of a contractor being able to apply on a monthly basis, you'd be allowing them to apply every 2 weeks, for example. It also allowed for increased speed of payment. So instead of the usual 30 days, you might have considered moving that down to 14 days. There's also advance payments. So for public sector bodies, that's not usually an option available under the JCT, but they said actually in these circumstances it might be appropriate to have that, of course, alongside an advance payment bond. And then the final of those 4 forms of relief was payment for works not yet done, and that was calculated on an averaged 3 months worth of interim applications, and you'd be then making that as a kind of contribution towards COVID hardship, as it's referred to in that guidance. I think it's important to also say that alongside those 4 forms of relief that the government set out, those forms of variation also place certain conditions on the provision of that relief. So this isn't just a, we'll give you extra money and there's no caveats here and there's no conditions on that. There absolutely are, and they're to also safeguard the position of the employer. So in summary, they are open book accounting, a prohibition against double counting relief. So if the contractor is receiving relief from central government through a furlough scheme or something like that, they can't be double counting that. The variations are based on being time limited. So when this was published, they'd mentioned the date of the 30th of June, but obviously it's open to employers to set a date that they're comfortable with. It's predicated on the contractor continuing to pay both employees and their supply chain. It allows employers to recover the relief if it's used for a purpose other than that which it was intended to be used for. The contractor shouldn't be putting themselves in breach of any other financial covenants, and also importantly, it's accompanied by a waiver of the termination triggers. So the whole purpose of the relief is, of course, to ensure that construction continues. So what you don't want is to have then tripped up over the termination trigger that David mentioned, which was your contractor notified of a force majeure relevant event, your 2 months got ticking, you're offering all this relief during that interim period, and they then turn around at the end of the 2 months and say, well, actually, we're going to terminate the contract in any event. So that's what's contained within that form of variation. So the guidance in practice, what should we have been doing? What should we still be doing? So I think it's essential that contracting authorities are proactively assessing and identifying at-risk contractors. However, it's worth noting, particularly at the commencement of the lockdown, most contractors would have fallen into the category of at-risk. So, and needing some form of relief or assistance from a financial perspective. I think it's really important to assess each contract individually and each contractor individually. Like with any decision-making process, you need to assess each situation on its own merits. I think what has been what I've seen in terms of best practice in terms of our clients is that some have made really great headway in producing internal guidance for their project managers, and also being very clear with their project managers about what the sign-off process is. So who do they need to have sign off any form of relief that they've decided would be appropriate for one of their contractors that they're working with. And also the kind of last bullet point there about appraising consultants of the options. Obviously, a number of our clients, if not all of them, work with consultants either in the capacity as employer's agent or in other guises. And I think it's really essential that you make clear to them, this is the approach we're taking, this is when and what form of relief we're willing to offer, because obviously they each have their own experiences and views, but you as a contracting authority need to be clear with them, this is how you want to manage your sites and existing contractors. And then I've put a link there to a piece of guidance that's been issued by the Construction Leadership Council, and they've issued it because I think and David will no doubt support me when I say this, I think there's a lot of contentious construction lawyers out there waiting for a number of disputes to come about in a few months' time through people who've somehow got themselves slightly tied up in knots by not taking a kind of logical and formal process to award relief or to assess extension of time claims. So that Construction Leadership Council guidance very much addresses those kind of issues, and what it's saying is it's important to ensure that you approach these things in the right way. So it's absolutely right to take a collaborative approach, but there needs to be some guardrails around that. So when you're setting out in those conversations, it needs to be clear that it's without prejudice and subject to contract. So that any relief that you're willing to offer has to be formalised through a variation, essentially. And what that does is mean that your existing contractual machinery stays in place until such time as you've agreed what that relief looks like and you've formalised it. Again, the guidance also mentions waiving of termination triggers. And largely, I have to say, mirrors the 0220 guidance, but it is a helpful follow-up, and there are some pro forma letters in there which may be helpful. So again, the Construction Leadership Council has been very busy, and I'm sure you'll all be only too well aware of the site operating procedures that have been published. We're now on our third iteration of those, the latest having been published following consultation with Public Health England. As mentioned on the slides, the measures recommend the implementation of a number of measures to ensure safety on site, including the social distancing of 2 metres. And these measures are the ones that really, in terms of contracts going forward, will cause the most discussion, I think, because as we'll all be aware, the compliance with these measures by a contractor will likely, if not almost definitely, result in them incurring additional costs. And it's then about who bears the cost and how that's formalised through your contract. So SOP, as I like to refer to it, I see really as option 5 in terms of relief. So we talked about those initial 4 options that were provided for under PPN 0220, and in my mind the SOP is slightly different, and it can be distinguished from those forms of relief for the following reasons. One, whatever financial arrangement you come to, it won't be on an assumed or average basis. It's going to be about costs, demonstrable costs incurred or to be incurred by the contractor. These costs could be ongoing with no finite end date, and the contractor has time as well as cost implications associated with implementing these measures. So for certain projects or phases within a project, these measures will have a far greater impact than at other times. So all of those things make this a far more complicated and difficult issue to navigate than those other forms of relief, which are all relatively straightforward. So I think, again, it's essential to remember that CLC guidance about maintaining the existing contractual machinery until such time as you're clear as to what relief or contribution you're willing to make. And I think essentially when it comes to site operating procedures, it's really important, as I've said here, that as employers you're not either approving measures that the contractors are coming up with or issuing something that might constitute an instruction. Now, we have seen some rather sharp practices already on this point, and I won't name names, but there are some contractors out there who have obviously taken a corporate view on how they're going to deal with this and are writing a very politely worded letter, but essentially it ends with, and please can you instruct us to implement these measures? And what I'm saying is, no, we're not approving, we're not instructing. It's down to you as contractor to decide how and in what form you comply with those measures. But notwithstanding that, and without prejudice and subject to contract, the employer may be willing to reach some sort of arrangement with the contractor with regards meeting the cost implications of that. I've put a point up here about just parties remembering their obligations under CDM. Particularly for the employer, that would be regulation 4.1 and 2 in particular. So it is important for employers to be appraised of those measures, of course, and to be actively monitoring. We just don't want to stray into the territory of approving and instructing. And then the last point there, of course, is about codifying any relief that you'd be willing to offer on the SOP front. Again, slightly more tricky than the others because it may be that you're not just offering a form of monetary relief or contribution. It may be that there's a time aspect there. We have prepared a variation which covers the site operating procedures, which does seek to align and adopt much of the drafting from the government's previous templates, but it has been necessary to move slightly away from some of that because of the slightly different nature of the SOP. I think the key for me in terms of any variation on the SOP is about the fact that there's no finite end date, but I think for employers you will want to have a specified date at which that initial variation comes to an end so that you can, before that date, have a review and see whether it's something that needs to continue or not, but also have something in there that says it ends on the earlier of that specified date or when the measures are lifted. So if the contractor isn't being required to put them in place anymore, obviously you don't want to be paying for those measures. Oh, I think I might have gone too far. Hang on a second. Oh no, I haven't. I've just lost my way. Sorry. I can't even blame the technology for that. It's just my Friday brain. I've obviously exhausted my capacity to even drive slides by this point. So this is just a kind of wrap up in terms of variation. So as I've mentioned, the government's offered various template drafting. I have actually tweaked that drafting slightly. That's for two reasons. One, it needs to fit with the underlying contract. So many employers have their own set of standard amendments. You just need to be making sure it's not I'll just grab it off the shelf and send it to the contractor job, unfortunately. And also there was a couple of bits where clients have wanted something slightly different to the government options. So it's not like you have to use that word for word. You can fit it to your requirements. As I've said there, that's all about considering and fitting the variation on a project by project basis. It is possible to include some additional parameters, so it may be, particularly if you're covering costs of additional measures, about receiving quotations and that kind of thing for value for money purposes. And then I think we've probably all slightly forgotten that as public sector bodies, we're caught by the public contracts regulations. So when it comes to modifications of existing contracts, we need to be mindful of regulation 72. So unless you've got a safe harbour under that regulation, you shouldn't be modifying existing contracts. I mean, I think there's definitely some safe harbours available within regulation 72 for the kind of variations that we've been discussing. And I think the risk of challenge would be incredibly low because essentially most contractors are being offered relief of this nature. And then the last point on there was just about the form of execution. So many of our construction contracts are executed as deeds, and therefore any variation to them should be executed as deeds. But currently we have a number of clients who are not able to access their seal. So I think you have to take a slightly pragmatic approach about how you formalise that variation, and I think Michael will come on to that in a bit more detail within his slides. And just to say before I hand over control, I have been, can't help myself, I have been responding to some of the Q&A as they've been coming in. So if I'm able to, I will, but if not, we'll pick them up at the end, as David mentioned.
So hopefully I will now be on your audio. So yeah, I'm Michael, as introduced earlier on. Before going on to execution, etc., as Rachel mentioned, I'm just going to briefly talk about PFI contracts. Because I'm sure lots of you might be considering on managing PFI contracts, particularly related to maintenance to do with things such as schools and waste facilities. I know that we've had a lot of queries to do with disputes over PFI in light of COVID-19. So the good news is that there are similar contractual mechanisms available in PFI agreements as per the standard form of construction contracts. So it will vary on the PFI agreement in question, but generally speaking, the position is broadly similar across them. So we have force majeure, as David mentioned, depends on the definition within the contract and has it actually affected the contract's performance of the contract. You have relief events or similar. You can have possibility of variations and also emergency provisions which may reflect changing service requirements and the ability of the contractor to deliver them as well. The Infrastructure and Projects Authority has published guidance on PFI contract management. It's quite similar to PPN 220. It's perhaps a little bit more focused on service continuity for essential services rather than supply relief, but the broad basis is the same, that people should be flexible with how contracts are managed. They shouldn't be continually relying on saying, if the contractor wants some kind of relief, saying no, 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 no. If the emphasis should be on how do we keep these key services continuing. But I won't prejudice too much because you'll be delighted to know that we have a webinar in the future on PFI and COVID-19, and do contact that email address on the slides there if you're interested. And indeed, that email address can be used for any assistance you might require on COVID-19 related queries. So moving on to what if we're yet to execute our construction contract, which can often be, sounds quite boring, or just dotting the I's, crossing the T's or signature, but it can be difficult at the best of times, and is even more difficult with remote working. Hard copy execution is difficult. People are in their homes, how do they receive the copies, and especially with execution by seal. Not the kind pictured on the slide, but the kind of stampy sort of seal, which, as Rachel mentioned, most local authorities will be executing their construction contracts by. The good news is that case law does confirm that electronic execution is perfectly valid as a form of execution. So when we're thinking of the perspective of the contractor, who in most instances will be signing things via two directors or a director and witness, the way you can go about that is through electronic signature. So they can print the contract in question, sign it, scan it back, and send it to the employer for further execution. Obviously, with shorter agreements such as collateral warranties or parent company guarantees, you can print out the whole thing. That's obviously not feasible with a huge construction contract, which can run to thousands of pages. On that instance, you have to print out the signature pages, sign them, scan them back, and then return them with the rest of the completed document. Now, with sealing, that's obviously a bit more difficult because people don't necessarily have access to their seal, and things like DocuSign, which is more common for people that can execute things under hand. Although there are software available to have electronic seals, most, I mean, I haven't come across any contracting authority that uses them. There are those available. It might be a matter for certain authorities to consider in future, particularly if we continue remote working, whether to use them or not. The alternative, though, however, in that instance where you haven't got access to your seals, you might want to consider alternative written agreements clarifying the contractual ways of binding each of the parties. So, for example, you may want to put something in writing to the contractor saying that the form of electronic copy that you've sent to them and that they've executed will form the purposes of a binding contract until you are able to formally execute the contract, when you're able to have access to hard copy documents and seal as well. Alternatively, you might want to think about how can we check or amend our internal governance documents, which probably dictate how you execute certain contracts, whether they can be executed underhand, whether they can be executed by seal. I think the other point I'd raise about electronic signature when it comes to the contracting side is that it's just as important to make sure they validly execute it as make sure that you validly execute it, is that you have to think about the witnessing requirements as well, that it's unlikely that you're going to have two directors living in the same home. How are they going to have access to witness? Because you can't witness something electronically. So that's just something to consider when making sure that the contract is validly executed by the other party as well. We have got more detailed guidance on electronic execution, which the link is available below.
Yeah, I think I just add there that obviously Michael mentioned where you're not able to seal, and thank you again, Michael, for the image on this slide. I'm sure all the lawyers on here have appreciated that one. But I think essentially we do need to, as with the notification of the relevant events, it's taking a slightly pragmatic approach here and doing the best that you can in the circumstances that you're facing. So absolutely, it needs to be in writing. The intention needs to have been shown by both sides. So do everything within your power to illustrate that you're being bound by that contract essentially, or that variation.
Thank you, Rachel. And as I said, we have, in my experience, we have been able to validly execute contracts despite COVID-19. So hopefully that continues as well. So what about if you're not quite at that point of, we're not just at the point of putting our signatures on the line. You might be in the course of negotiating the contract, or in the course of procurement, or indeed beginning of procurement. And you'll have to think about things from a risk assessment, options appraisal point of view, judging each project on a case-by-case basis. So things that you might want to consider is the timing of projects. What are the duration of the works? Are they going to be affected by new site operating procedures? Are they part of a wider scheme which certain things have to be met by? Can the risk be allocated between contractor and employer in a satisfactory way? So COVID-19, although if you're entering into a contract now, as Rachel and David touched on earlier, is unlikely to be a force majeure, there is obviously going to be ways in which the works are affected, and there has to be a satisfactory allocation of the risk between the contractor and employer, if appropriate. And the cost implications, does it cost the same? Probably not, because of the site operating procedures, costs will increase in terms of the contractor. Is the contractor reflecting that on their pricing for the contract? Do you have other cost pressures that you have to deal with in terms of other projects or other pressures, things like that? Are there possible alternatives to the project available? Does it have to be completed in when it's done? Can the scope be changed? Is it more or less important than other projects? Is it possible to achieve changes with appropriate sign-off in a timely manner? So when you're thinking of your governance, there might be certain sign-offs within your authority as to how you can actually achieve the changes of the contract and the prioritisation of certain projects as well.
Yeah, so I just add on that one. I know there's a few questions that have come in, because I think this is the bit that's causing the people most angst out there, which is the ones where you haven't yet entered into contract yet, and what you're being faced with is a number of requests from contractors for very open-ended drafting in respect of COVID-19, and obviously you need to be very wary and mindful of ensuring that you're protecting the employer's position when agreeing any drafting reflecting COVID or kind of second wave scenario within any of your contracts going forward. I think it's important to note that the Secretary of State for the Ministry of Housing, Communities and Local Government has also issued a statement in terms of the time impact, saying that he's making it clear that with immediate effect, local planning authorities should take a swift and positive approach to requests for greater flexibility around construction site working hours. And I've seen references to sites being open until 9 o'clock in the evening. So I think when you're having that discussion on without prejudice and subject to contract basis with your contractor, when you're about to enter into contract, I think it's about saying, okay, can we reflect within the programme what the time implications are? If you're going down that route, I think it's really important to ensure that your contract reflects that your programme has taken account of those impacts. you need to avoid double counting here. What you don't want to do is for somehow the contractor to come get into contract and then somehow argue that it didn't provide for all of the impact within the programme when you know that they did. And also to obviously be mindful of consultation requirements with residents and that kind of thing for extended working hours, which will ease some of the time pressures of the measures, because essentially what they're trying to do is ensure that the social distancing is provided for on site through those extended hours. I also think that on the costing side of things, again, what we're trying to encourage is that there's a detailed breakdown of what those kind of additional COVID costs are, if you like. And again, I think what you want to try and do is avoid things falling under relevant event and particularly relevant matter regimes, and where you've accounted for those issues being expressly recognising that you have within the front end drafting.
Yeah, absolutely. A rather more straightforward point as well. Sorry, not straightforward, but sort of noddy point. I've recently advised on a contract not yet signed, where the contractor was already making applications for compensation events prior to the contract being executed. Obviously, that doesn't work. You need to have a dialogue with your contractor and make sure that what the agreed position in relation to COVID is reflected in the contract documents, rather than them trying to come back with variations or compensation events for a contract that hasn't yet started.
Yeah, thank you, David. I think, and Rachel as well, I think as with all these things, it's important to make sure you get all these things in writing, and that applies for during the contract as well. And so if you are talking about ongoing procurement, so you're right in the midst of a procurement for a project, the procurement documents you have, or indeed if you're beginning your procurement, should always provide for abandonment by the authority, suspension by the authority, and reduction in the number of tenderers, provided that obviously all those things are subject to compliance with public contract regulations. And that should provide you with some kind of flexibility as to how you deal with certain projects that you're yet to enter. The important thing to think of is we shouldn't always be thinking of ourselves, that we shouldn't be thinking it's difficult for us, so we're going to make it as difficult for the other side. Is that bidders and contractors are also having difficulties with remote working. That's going to make it more difficult to meet certain timescales for completing bids and things like that. So there has to be some kind of flexibility with the timescales for tendering. So think about how documents might provide for amending the timetable, and indeed the reduction number of tenderers would also aid in that goal as well. And then finally, obviously, you have to think about what is actually the form of contract we're going to enter into. Should our amendments be changed to reflect certain risks that have come out of COVID-19? And again, is there an appropriate allocation of risk between the employer and the contractor in light of COVID-19?
Yeah, and I think we've had a question right at the top of the session actually about reflecting or asking questions about COVID-19 in the procurement documents or the evaluation. I think we have to be slightly careful because it's very, very project specific in my mind, because it really depends on when those works are going to be taking place, about how much you would want to kind of weave COVID-19 into your evaluation, particularly when we're talking about any cost implications and trying to evaluate that, which I have seen this week, because actually we don't know how long these measures will continue for. So if you're evaluating costs that then don't come to light or don't last for a particularly long period, you're skewing your evaluation just to take account of that. So I think you have to be quite careful, but I can absolutely see that it would be possible and appropriate to address some of those COVID-19 health and safety issues within a health and safety style question potentially. That again depends completely, I think, on whether your project is starting beginning of next year or end of next year, or the timing essentially.
Yeah, I think that's true of all these things. It's very easy to talk about COVID-19 as being this unprecedented event. I think we probably had the word unprecedented used an unprecedented number of times, but it's all about how does it actually affect the project in question. There's a second step to all these problems to consider. And that kind of leads quite nicely onto the final point here about Regulation 32 on public contract regulations, which is to do with certain urgency provisions, how the obligations on contracting authorities are somewhat loosened in those contexts. When COVID-19 kind of first began as a proper issue in sort of March, the European Commission did say that COVID-19 would amount to an urgent event for the purposes of Regulation 32. But again, you actually have to be able to prove how it affects the procurement in question. You can't just say COVID-19 is urgent, therefore we can rely on these provisions. You have to be able to demonstrate a link between the two. And secondly, as we move on with COVID-19, it's clearly becoming not as urgent. We are all aware of what it is. And it's also important to remember those points that were raised by the European Commission back in March are only guidance. They can't be used as a catch-all for all possible situations. But again, we've got more guidance on this and other procurement matters for things beyond construction available on that link in the slides as well. So finally, before I hand back to David to go through some of our questions, we've got lots of resources online, including a Sharp Focus Special Edition, which covers a whole range of issues on COVID-19, which I'm sure you'll find very interesting. Particularly if you can't go out the weekend, you can have a read of those. And indeed, obviously, you can contact any of us with regards to any more specific queries with our details there as well. So I will hand back to David to go through the questions.
Thanks very much, Michael. We have a lot of questions in. Some of these I think have probably been already dealt with.
Yeah, so I think there's 5 in the new category that I haven't quite got to yet, and there's 14
right
in the published. So I've just been trying. I mean, some of them I think. So some of them have probably been covered in what we've spoken about. So there's one from Anonymous, which says, if we have procured a contractor for works but not yet entered into the contract, what are the key considerations in deciding whether to enter into the contract immediately or to wait? Should side letters be avoided if at all possible? On the second point, that's a very easy one to answer. And yes, is the answer to that. Side letters, letters of intent, still well clear of those. I wouldn't want to use them even in normal circumstances, so entering into one of those during a global pandemic is definitely to be avoided. And then in terms of that first part of the question, key considerations, so again, I think this is all about timing, isn't it? So when is your construction contract meant to be starting? How long is it meant to be going on for? Are there works that can proceed at the start of that contract in light of the measures that have been imposed? So can they make some reasonable progress without too many issues? I mean, we've had a number where there's been a kind of design phase, which takes them kind of 2 months into the project timetable. So actually, it's been felt that that can proceed quite easily at this point in time. We have also, in terms of contractual provisions, I think it's worth mentioning, now that I mentioned that design phase, we have also, with one of our clients, introduced a break clause, which takes effect at the end of that design period. So even if you feel like, okay, there's some work that initially can absolutely be done and it's in the interest of both parties to do it, you may want to give yourselves the option to break after that work's done, if it's felt at that point in time that the situation has changed or worsened and actually you can't proceed with the rest of the work. So that might be a solution in some situations, but subject of course to agreement by the contractor. And then I think it's also about what is your internal view of the risks at this point in time? Are they quantifiable? Are you able to draft provisions that you feel comfortably allow the contractor to continue and meet the additional costs that they're faced with, but aren't so open-ended that the employer essentially doesn't know what they're approving and signing up to, that kind of blank check territory. So I think it's the usual kind of considerations really at this point in time. So I think that's what I'd say about that one. So hopefully that's answered that question. Just scrolling down, what's your advice on what provision is required on contracts that were tendered before COVID-19 and for which we are not yet in contract? Okay, so you went out to tender with a kind of, one would imagine, an amended standard form, but nothing said about COVID-19 in it. I think this is the kind of territory where you'd be having that collaborative discussion on a without prejudice subject to contract basis, asking the contractor to confirm the time and cost implications that they foresee as at today's date essentially, and then seeking to agree some amendments to the contract potentially to reflect the arrangement that you're willing to enter into, to take account of those two things. Again, like I mentioned earlier, if you're extending the programme, then it needs to be recognised within the contract that you've done that and you've already accounted for that time impact. If you're agreeing to costs, then very much the same goes for that.
Yeah. There's one here. Given some construction sites weren't really ordered to shut down, given the ambiguity, would force majeure be upheld when the inability to obtain materials, or would that be more towards frustration? As I say, none of these things are a blank check. We certainly can't say at the top of this that COVID is a force majeure event. It depends on the delays that are being talked about, and it depends on the particular wording of your contract. So by no means certain to be a force majeure event. You need to actually look at the circumstances that have happened on site there. In terms of frustration, as I say, frustration is the circumstances where it becomes essentially impossible to continue with the contracts for reasons that neither party could possibly have known about. Frustration is an enormously high hurdle to reach. It's one of those things that's very rarely the courts very rarely agree has happened, and so I'd be very surprised if we get into frustration territory very often.
Yeah, so that was that one. So I think scrolling up slightly, there's a question here. JCT intermediate contract with contractor's design not yet awarded, where design period and possession of site is not clear in the tender documents and the practical completion date has changed, as well as the deferment of possession period was considered not applicable pre-COVID-19. Is it worth agreeing a deferment of possession period with the contractor, documented in the contractor's revised work programme based on revised practical completion date? Essentially, yes. So I think absolutely, I think it's right that you consider a deferment of possession and potentially extending what's set as the default period for deferment as well. And deferment of possession also has a link through to the termination triggers, so you just want to be thinking about that as well and ensuring you've covered that off.
Absolutely. I'm going to cheat and do the easy one right at the beginning of all of these. In an NEC contract with the COVID Act coming into place and X2 in place, is a contractor entitled to a compensation event? Essentially, yes. With X2 in place, that allows them to have a compensation event for a change in law, and the COVID Act of 26th March is certainly falls within that situation. But what I would say, of course, is again, it depends on the circumstances. So they get a compensation event, but you really need to look at how that compensation event is assessed, what time they should have and what money they should have. And in each case, it needs to run directly from the compensation event and not be sort of tied into all the other delays that might have happened on site.
Okay. And I think there's only one left that we haven't either verbally responded to or published a response. I think it's on mature PFI projects. It seems to be slightly straying into more general contract advice territory. So I think we might just have a little think about that one and then send our response out if that's okay, because we're getting into territory of poor delivery. But I think it's probably going back to that point that David made, which is that I think it's very easy for these things to be conflated. If there was poor service delivery before COVID-19, then that needs to be assessed and dealt with in accordance with the ordinary contractual provisions, and then COVID-19 has to be dealt with in its own right as a separate matter.
That's great. I think that's all of the questions that we've had. Many thanks everybody for joining us today, much appreciated, and thank you for all the great questions as well. It's good to see you. As we said, there's another webinar coming up, I think next week, in relation to the effects of COVID on PFI contracts. Please do sign up for that. But thank you again. See you soon.
Thanks everybody.
Thanks everybody.